Australia's policy on boat refugee. The boat people issue isn't a new phenomenon in Australia. According to an Australian Parliamentary Library research paper, the first boat people arrived in April 1976, five Indo-Chinese men during the Vietnam War, and it is since that time that the term boat people has been used and entered into the Australian vernacular. The Vietnamese boat people enjoyed public sympathy. However, during the federal election of 1977, the boat people issue became political for the first time because of increasing unemployment. Consequently, when the refugee boat arrivals increased over the next few years, the media and political parties labeled them an invasion and a flood. Since the 1977 election, both people have been at the center of Australian politics. In the last few decades, Australia has amended its immigration laws on numerous occasions and adopted several policies to stop the refugee boats by branding them as illegal migrants. It has adopted both a mandatory visa system and pre-checking system before arrival into its territory, as well as various deterrent policies such as the interdiction of asylum seeker boats at sea and sending the boat people to remote locations. According to the policy, all asylum seekers who arrive by boat are detained and transferred to Christmas Island, primarily to investigate their reason of arrival by boat. Moreover, Australia implements various extraterritorial mechanisms as offshore barriers to stop the entry of illegal migrants into the country. These include visa requirement, carrier sanction, the Airline Liaison Officers Network or ALO, and the Advanced Passenger Processing or APP system. Regarding Australia's extraterritorial mechanism, Secretary Taylor observed that, in fact, the territorial border is becoming less and less important as a site of immigration control because most of the real action in that respect is occurring offshore. In addition, asylum seekers who try to arrive in Australia by boat are described in a negative way in media coverage. They are called queue jumper or economic migrant. Moreover, the media voiced concern about potential threat to national security and border protection in line with public sentiment. This led the government to adopt hostile rhetoric and policies to deter the boat people. It is also worth noting that the Commonwealth of Australia Constitution Act 1900 is the supreme law of Australia. In fact, Australia is a federation of states where each state has its own constitution, government, and laws. The Australian Constitution was created as a settlement under which the previous colonies came together as states in a federation. However, Part 5 of the Constitution empowers the Parliament to pass legislation. Section 51 provides details of the legislative powers of the Parliament, declaring that the Parliament has power to make laws for the peace, order, and good government of the Commonwealth with respect to the naval and military defense of the Commonwealth, naturalization and alien, immigration and emigration, and in respect of external affairs. Section 52 also confers exclusive powers on the Parliament to make any law for peace and order. Further, Section 61 of the Constitution creates the executive power. Section 61 provides that the executive power of the Commonwealth is vested in the Queen and is exercisable by the Governor-General as the Queen's representative and extends to the execution and maintenance of this Constitution and of the laws of the Commonwealth. The scope of the executive power has never been defined under the Constitution. The executive power is described as the inherent power and the nationhood power. Peter Step-Hansen notes that the meaning of Section 61 can only be properly understood if it is considered in the light of British constitutional history, convention, and the common law. In fact, the executive enjoys a vast power to perform all the action of government. In Victoria versus Commonwealth and Hayden, the nature of the executive power was examined. Mason G. opined that executive power of government means a capacity of engage in enterprises and activities peculiarly adapted to the government of a nation and which cannot otherwise be carried on for the benefit of the nation. Accordingly, refugee issues are a federal concern that has come to dominate the political agenda in Australia, with the government adopting restrictive policy to manage the issue. The study now turns to Australia's boat refugee policy and will examine how the federal government has dealt with boat refugee in practice. 1976 until 2001 Detention Policy on Boat Refugees. According to the report of the Parliamentary Library of Australia, the arrival of refugee boats in Australia is divided into three waves. The first wave of boat people was during 1976 until 1981. The second wave during 1989 until 1998, and the third wave during 1999 until 2013. In the first wave, 2,000 Vietnamese boats arrived in Australia. In the second wave, 6,000 boat refugees arrived, mainly from Cambodia, Vietnam, and southern China. And in the third wave, 56,000 boat refugees landed in Australia, mostly from the Middle East with the assistance of people smugglers. In the 1989, the UNHCR initiated an international agreement, the Comprehensive Plan of Action or CPA, which aimed to solve the Vietnamese boat refugee crisis by either resettling the Indo-Chinese boat refugees in a third country or repatriating them to the country of origin. According to the CPA, Australia accepted 16,000 Vietnamese boat people through the offshore humanitarian program, with the last Vietnamese boat arriving in Australia in August 1981. However, during the second wave of boat people, especially those who arrived from Cambodia, it was discovered that not all the boat people were bona fide refugees. Many of them were economic refugees. As a consequence, in 1992, the Keating government adopted the policy of mandatory immigration detention for unlawful arrivals of boat people, which was made law by the Migration Amendment Act 1992. Prior to 1992, detention decisions in respect of unauthorized boat influxes were on a discretionary basis under the Migration Act 1958, Section 38. According to the Refugee Council of Australia, it is estimated that almost all boat refugees were given refugee status between 1976 and 1981. And between January 1976 and June 2015, it is estimated that 30,000 boat refugees were given protection. Operation Relax was introduced after the Tampa affair of 2001. At that time, the Howard government implemented a number of policies and mechanisms regarding irregular migrants. These are known as the Pacific Solution. The Operation Relax policy was introduced under the Pacific Solution. As part of the change, the Border Protection, Validation and Enforcement Powers Act 2001 was adopted. The purpose of the Act is to safeguard the domestic legal action that are taken into relation to foreign vessels with the territorial sea of Australia. Thank you.